All right. Good afternoon, folks. This is the Colorado Oil and Gas Commission getting started for its afternoon session on day 9. We are in the middle of deliberations on the 400 series, which is the sort of operational series. I had some good discussion this morning. Just as a reminder, the procedural method that Commission has chosen to do its deliberation is we will do the issue identification, which we've got before us on Ms. Murphy's screen. We've been going through each of the issues and identifying sort of conceptual direction to staff, asking staff to then go back and create a final sort of red line for distribution back out to the world and to us. And then we're getting that work product on each of the series. We don't have any of it yet, which is fine. A formal final deliberation is sort of the latter part of the next week, but we will have all of this information before us as we go into sort of a formal final deliberation on all of the series. We chose this path because it allows for the 5 different series to be interconnected when we look at the very end game, and some of the issues in 300 can correlate with the 400 discussion that we were having today. As we heard from staff this morning, there's a lot of interconnectivity there. So with that, I think that we got through most of the nuisance sort of issues, and I think we still have lighting to work through. That's slide 9, Rule 424. Unless there are questions from commissioners, I would call upon Director Murphy to light up this issue for us.
Oh boy. I think we should start keeping tabs on the number of bad puns for the day, right? I made one about noise earlier to staff, so I'll try to dial it back. But so I think when it comes to 424, we've heard a lot of information from stakeholders. And what I would offer is that from staff's perspective, this is unlike a number of the other nuisance regulations. This is one of our first forays into really creating a substantive requirement, and we think that there is much to be learned. And so from staff's perspective, I think that there's a lot to digest, and a working group to come up with guidance or rule revisions makes a lot of sense. That being said, our current rule largely doesn't function when it comes to lighting, and so we do think it's important to adopt a rule that we can enforce moving forward, recognizing that we can come back to you with revisions and work through some of the challenges raised by stakeholders with guidance developed through a working group, given the level of expertise that we can draw upon outside of our agency.
Sorry, muted. Do commissioners want to weigh in on Rule 424? Commissioner McGowan.
Thank you, Mr. Chair. I appreciate Director Murphy's comments about this section. I also was very interested in, I think it was Adams County, talking about a lighting budget and kind of a different way of looking at lighting. I thought that was compelling, which is why I'm supportive of a working group that might be able to revise and look at this, but I also understand that we need something in the meantime. So
Commissioner Messner.
Thank you, Mr. Chair. And I agree, Director Murphy. I think that this is a good first cut. I think that the draft rules as proposed do, I think create a pretty good plan, or at least a good rule. But I think there is benefit to having a working group in order to refine that. And so I would be in support of that.
Other commissioners with thoughts, comments, questions, suggestions? Commissioner Nanjapa?
Mr. Chair, I would also support the idea of a working group, and but also concur that I think that we've got some good information to go from here.
Commissioner Gonzalez, did you have anything further on that?
Nothing further. I'm good with that plan.
All right, let's move off of lighting, and Director Murphy, where would you like to go next?
I guess part of today's discussion, or to Tahiti, because they're different answers. But my suggestion, Chair, this morning was that we get through the nuisance stuff, which we've done, and I think we've had an incredibly helpful, robust conversation. We're excited to work on the direction we've gotten from commissioners on those topics. This morning, I'd suggested we work kind of in reverse order at this point in time, but we certainly don't need to. So if you do want to go in reverse order, the next topic would be rules 412 and 420. I think these are pretty focused conversations. I'll need a little bit of insight or context probably from commissioners about them. The only other thing is if we wanted to just tackle kind of the big other pretty technical, pretty substantive issue, I think is rule 411.
Commissioner Messner, you had your hand up.
Thank you, Mr. Chair. So I did have one question, because before we go on to the other topics and staying on nuisance topics, there was one item that was brought up in 426, and I believe it was 426F, and it was questioning whether some of the suggested best management practices that were within the rules should be in the rules, or whether they should be within guidance, understanding that within the rules it does say may include but are not limited to, and so I do understand that. But should there be specific suggestions for best management practices within the rules? So I don't know if other folks think that's something that we should discuss.
Commissioner Gonzalez.
Thank you, Mr. Chair. I think there was some compelling arguments about not having best management practices in the rules, as they may set an unrealistic or unnecessary baseline that eliminates the ability for some flexibility for various siting locations. And so I'd like the best management practices to be developed by the operators and then proposed to staff, or staff would have some influence on ensuring that they meet the rules, that they are protective in nature, that they are in fact best management practices. And I've seen in my experience that staff is not hesitant to push back on other operators and say, hey, operator X is doing this. We'd like you guys to consider doing that as well, and really entertaining the evolution and development of best management practices through practice. So that's kind of my 2 cents on really codifying best management practices in the rules. I'm not a huge fan of it. I like seeing that development happen, kind of as new variables are introduced, as new technologies are applied, and as new kind of situational awareness and needs are developed.
So I guess I understand that point, and I understand the concept that, we don't want to codify things that are fluid and that get better as we get over time. On the other hand, the best management practices, which were include but not limited to, really were specifically addressing odor. And having been director before I became chair, I really appreciated the list of 6 practices as really being those practices that, at least in today's day and age, do address the issue of odor, which was one of the areas of complaint. So at least as to that area, and noting that it is a include but not limited to, I could be okay leaving them in the rule. If we don't have them in the rule, I certainly would want to have guidance documents that speak to them, because not all operators may have the abilities or knowledge about the where the BMPs are around odor in particular. So those are my 2 cents. I would look to see if other commissioners want to offer 2 cents. I also note that at least 2 of our staff members have shown up on the screen. So if Attorney General Minor or Mr. Leonard had thoughts about this issue, we would appreciate those as well. Director Murphy.
From our perspective, we await your direction on it for all the reasons that have been articulated.
Commissioner Gonzalez.
There are on number 2, so 426C2, the adding chillers to drilling mud systems. I thought I recall some concerns about that particular best management practice from one of the industry groups, particularly about the, I don't know if it was the viscosity of the mud and it changing by chilling it at the surface and then putting it down hole, as opposed to allowing it to kind of adapt to the changes in temperature as it went down hole. I don't know if I'm getting that right, but perhaps if there was someone who was listening from staff that may be able to address that concern, I would appreciate that.
Mr. Chair.
Mr. Leonard, please.
Yeah, I can address that a little bit. So the comment was made that the drilling fluid, the drilling mud is designed to work at bottom hole temperature, which is much higher than obviously than the atmosphere surface hole, or the atmospheric temperature. I thought that was an interesting conversation because chillers are used on a regular basis. I mean, that was one of the first attempts to mitigate odors by lessening the and I can't think of the word, but when the hot fluid comes to surface, it vaporizes off. So the idea of the chiller is to cool that off and keep that vaporization level at a lower point. And again, it's been used many times. So unless someone has a different mud chemistry that doesn't allow it, and that's why there's all the other options.
So it's consistently being applied across basins across the state?
No. It's specifically used in the DJ Basin where we're using the oil-based mud, and in proximity to residents where there may be odors emitted. Other parts of the state, I can only think of one other part of the state, and engineers will correct me, that use anything other than water-based fluids.
Thank you, Mr. Leonard. Yeah, if it's being consistently applied in the basins where it's being used, maybe I don't understand the objection. So appreciate the feedback there.
Other thoughts from commissioners on this topic? Commissioner Messner.
Thank you, Mr. Chair. So I think I'm of the opinion that I think that these are good best management practices, and I do, while I do acknowledge that it says may include but are not limited to, I think including these in guidance may make the most sense, because these rules, will last for quite a long time. And I do think that there will be technologies and other ways of addressing odor that, could evolve. And, as I've seen, technology does evolve quickly. I would perhaps utilize language in there that would reference the fact that best management practices are indicated within the guidance. But I'm not hung up one way or the other, but I do think it's a valid argument as whether or not specific best management practices that could change should be codified.
Commissioner McGowan, Commissioner Nanjapa, do you have any thoughts on this issue? I'm not hell-bent on keeping it in the rule. I just, if we're going to do guidance, let's do as Commissioner Messner says and make sure that, that we're referencing guidance that is developed and that is always, top of the line, gold standard sort of stuff. So I think I'm seeing thumbs up and nods. So why don't we land this in that spot? And Director Murphy has appropriately captured this direction in the miscellaneous piece under 426F. Do we want to now move back to, what was it, 412, Director Murphy?
We can, I mean, commissioners, if you want to try to knock these two miscellaneous ones out.
Let's do that. Yeah, let's just stick on the slide. Let's have a discussion around the red, yellow, green light, or the 429, 430.
429, 430 is asking if staff is green lighted with the language it proposed yesterday to refine the meter calibration documentation at the location.
Commissioners, does anyone want to lead off on that? Commissioner Messner.
So this is the topic that was brought up, that should the report be sent out on calibration, or should it be posted on site? I think the explanation that was given yesterday in staff's closing statements regarding the rationale behind posting it at the site made sense to me, and so I'm fine with that.
Commissioner McGowan, you had unmuted. Did you want to add?
Nope, I agree.
I agree.
Same.
Director Murphy, was staff ready to talk about this geologic hazard? I know that there was some work being done internally, and I wasn't sure if that was finished yet.
Yes, Chair, I believe that we are. I think AAG Minor will touch on it. And I also just want to remind us all to keep it at top of mind that staff is also working on the direction from the commission to contemplate geohazards as part of the 300 series.
300.
And we have executed on it. We're refining it. And so that will also be coming forward. But with that, I would say AAG Minor, do you want to chime in, please?
Yes, thank you, Director Murphy. So staff has certainly reviewed the traffic light proposal and in fact agrees that many portions of it are a very good idea. And staff has actually in many ways already incorporated those concepts into proposed Rule 803 G6, which is where the seismicity review appears. You may not have done too much digging into that yet because that's in the 800 series rules. So again, staff has taken a careful look at that. Dr. Bob Kaler, who does the UIC seismicity program, has definitely been reviewing it, as well as I believe Mr. Eisinger, Diana Burns, sort of the whole seismicity team, and is, I think, very open to further discussions with the stakeholders who brought that idea forward about whether there are further refinements that could be made to proposed Rule 803 G6 to incorporate potentially additional provisions from the traffic light proposal. Again, there words like red, yellow, and green don't appear there. It's really just the concepts that are in there now. But staff would suggest that we have that conversation in the 800 series, which is where the seismicity review has been proposed, rather than trying to import it here into the 400 series, where staff did not propose it initially, just because stakeholders haven't had a chance to provide feedback on it in the context of 400 series and are certainly weighing in on it in their pre-hearing statements for the 800 series.
Commissioner Gonzalez.
Thank you, Mr. Chair. So when I was listening to this, I was trying to really piece together what the argument was in favor of seismicity checks and kind of Richter scales for seismic operations, because that's the context in which we were talking about it. And I'm curious if the concern around the geologic hazards in regards to these types of tests and this kind of green, yellow, red light system should be tied to seismicity associated with oil and gas operations, or seismic operations, which are kind of different things. And so I was curious if even the context in which that testimony was brought before us was maybe in the wrong spot. And so I want to make sure that I'm thinking about it the right way, because we talked about seismicity in the 300s in regards to geologic hazards and specifically in regards to siting. I don't know that we really dug into or connected that to seismicity triggers is not the right word, but it's the word I'm going to use, to associated with seismic operations. It's one point of clarification. I just want to make sure that we're all talking about the same thing, because we're in the 400 series. We're talking about seismic operations. Now we're talking about this potential TLS system. And so I just wanted to throw that out there, make sure we're on the same page.
If I may, Mr. Chair.
Yes, Mr. Attorney General, Assistant Attorney General Minor.
Thank you. Commissioner Gonzalez, you are correct. Those are very different concepts, which is, again, why I think staff would prefer to have this discussion in the context of the 800 series. So if you recall Ms. Stanzik's presentation on proposed Rule 313, the seismic permitting rule, she outlined that there are different definitions of the word seismic in the dictionary, right? And so where we see this discussion of seismic operations in the 400 series, that's talking about a very narrow thing of essentially creating some vibrations on the surface and seeing how they bounce back as a way of doing underground mapping. The induced seismicity that is addressed by the traffic light system, the TLS system that was in one party's proposal, that is an entirely different use of the term seismicity. That's talking about situations in which the injection of fluids into the subsurface could potentially cause subsurface shifts that result in seismic activity when sort of fractures are being lubricated. And I think we've now surpassed about my 3 college geology courses of knowledge to address that question. So I think if you have more technical questions on the distinction, I believe Mr. Andrews has been added to the Zoom and can answer those.
Mr. Chair.
Yes, Commissioner Gonzalez.
Thank you, Mr. Minor, for that. No, I do not have any more technical questions. I took Geology 101, Rocks for Jocks, as we called it, and didn't do so hot in it. So I'm going to leave it at that. But I do agree that potentially the discussion around this TLS system is not appropriate for the 400 series discussion we're having now.
Are other commissioners in agreement? Nod, up and down, thumbs. Commissioner Messner? Yeah. We can see our thoughts materializing on the page. Thank you, Director Murphy, for continuing to lead us in a distinctly great fashion. Do we now want to move to a discussion around 412? Director Murphy.
That is a great question. I might ask AEG Minor to talk about 412 if he's the right one. And perhaps, I think that also 420 we should flag is a conversation around Bradenhead, right? Or I'm just gonna turn over to AG Minor. He's like super ready for this.
AG Minor.
Yes, thank you, Director Murphy. Maybe I'll start with the last one, which I believe reflects that some of the commissioners may have provided handwritten notes to Director Murphy, and I wonder if that was actually intended to be a different rule, because there are not really wildlife implications of Rule 420. So perhaps if the commissioner who suggested that could speak up and sort of discuss the concern, we could deal with that. But I'm not sure that is where it belongs. Rule 420 is a Bradenhead testing and monitoring rule that was modified in the Wellbore Integrity Rulemaking.
All right, that's me. And so I clearly wrote down in my notes the wrong rule. So give me a second and I'll go back through my notes and see where I was referencing that issue that a stakeholder brought up and what actual rule it was associated with. So bear with me. I mean, we don't have to do it right now. Give me some time.
So, Mr. Chair, if I may suggest, then
yes,
I can
please
address 412A. So 412A is one of the rules that I discussed during staff's closing statement yesterday. It was one that was presented to you by Mr. Leonard during staff's opening statement. And this is the statutory notice to surface owners. So surface owners under the Oil and Gas Conservation Act are required to receive notice when certain activities occur on their property. Staff have implemented that in Rule 412A. Local governments received the same notice, and I believe that some stakeholders had brought forward a discussion about whether there should be perhaps a longer time frame in which that notice occurs. So in Rule 412A, it's currently 30 days before the commencement of operations with heavy equipment for drilling a well. So that category of operation while drilling, there's 30 days notice to a surface owner.
Commissioner McGowan.
Someone just, I don't know what the average, is that a, how far in advance does an operator know? So I'm curious to know how you came up with the 30 days and if 30 days is a typical time frame for knowing when you're gonna bring in heavy equipment. So I feel like I don't have enough information to know if that is a reasonable amount of time or not.
Mr. Chair, if I may.
Or Mr.
Yeah,
Minor.
I was going to actually kick that to Mr. Leonard. So there we go.
Can you ask your question again, please?
Sure, thanks. So I think we're talking about 412A, which is statutory notice to surface owners and not less than 30 days in advance of commencement of operations with heavy equipment. So I guess not knowing how far in advance an operator knows or doesn't know when they're going to bring in heavy equipment is the 30 days. How did we come up with not less than 30 days?
Mr. Leonard.
Okay, yeah, for a lot of reasons. You know, I think the advance notice, the 30-day advance notice is to allow the surface owner to prepare. And when I say prepare, think, think a ranch, they might want to move their cattle out of that pasture, or they may want to, I'm trying to think of another reason, but 30 days, a full month in advance notice, just so that you can prepare, I guess is.
Mr. Chair, if I.
Yes, Attorney General Minor, and then we'll go back to Commissioner McGowan.
Yeah, and Commissioner McGowan, just to answer your more specific question of how did we come up with it, 30 days is in the current rule. It's current rule 305F. I'm not sure when that was adopted, but it has been part of the Commission's rules for quite some time. So staff did not propose to change that 30-day time frame in this rulemaking. I'm not sure sort of how it was initially developed.
Commissioner McGowan.
And I'm supportive of whatever. I just didn't know, because I don't know how far in advance an operator would normally know when they're going to bring in heavy equipment. So typically they would know more than 30 days in advance, and folks want more upfront, heads up, then I'm supportive of that. I just don't know.
If I may, Mr. Chair.
Yeah, Mr. Leonard, before you answer, is this a problem that needs solving, or if we've had 30 days in the past, has that been working?
Are you asking me? Yes.
Yes.
I would answer yes.
Yes, that 30 days has been working.
The 30 days has been working. I don't know of any complaints saying 30 days is not enough.
Director Murphy?
Thanks. I think the other component of this is that we think it's important to know for sure that a surface owner is getting notice, right? They're being impacted, but often if there's a surface use agreement or other negotiation between the operator and the surface owner can can use that process to figure out when these things are happening. So if you're thinking about crop circles, and we often get questions from operators saying, hey, this land surface is in the midst of being used for X, can we defer doing some activity until Y? And so I think that it's not just our process that helps inform surface owners about what's going to happen and what is going on. And I think that might be why we don't hear about this very often, is that those other negotiations between the operator themselves and the surface owner help inform it. Our rules provide a backstop.
Thank you, Director Murphy.
And I'm also way outside my skill set, so if Commissioner Gonzalez wants to add some color commentary there.
Yeah, I will, Mr. Chair. I will add just a small amount of color commentary to directly answer Commissioner McGowan's question. I would say, in my experience, it varies when an operator knows exactly when they're moving equipment in. A lot of it depends on the rig schedule. It depends on the timing and the efficiency of the operations on the rig schedule before it. Sometimes it's accelerated, sometimes it's delayed. And so I would say that it absolutely varies. Again, when the notice that's dictated for service owners is typically defined in the SUA, in a lot of times, a service use agreement, which is a contract with the surface owner. And so I agree that with Director Murphy and Mr. Leonard, this provides a good backstop. And if there's any additional time frame that service owner would like to know, they have the opportunity to negotiate that into their private contract with the operator.
Thank you for those comments, Commissioner Gonzalez. Other commissioners with thoughts? Commissioner Messner.
And we're talking about 412A right now, correct?
Yes, I believe so.
And so if I remember correctly, one of the topics on this one was not necessarily surface owner, but whether to increase notice time frame to the local government. And I think there was a request to have 5 business days. Am I recollecting that correct? Are other folks remembering this?
I think that was the Plata County Coalition that spoke to 5 business days.
Correct. And so I guess my question is, does that seem like a realistic thing to do to provide that that amount of notice to local government concurrently with the service owner?
If I may, Mr. Chair.
AAG Minor.
So to be clear, Rule 412A does require that the relevant local government get notice at the same time as the surface owner, 30 days in advance. It was Rule 405 where La Plata County was suggesting different notice timeframes for local government of various operations.
Commissioner Messner, follow up?
I was just going to say that I withdraw my comments.
Did we want to move to 412B in terms of move-in rig up notice? And I apologize. Can someone frame the issue around 412B for me?
Mr. Chair.
Commissioner Nanjapa.
I think this is one that I raised, and I was just thinking generally about it, not just in this specific subsection, but in other subsections, the ability to provide some expectation of duration of the operations, so that, you know, whoever the surface owners, the building unit owners and tenants, et cetera, would be in 412B1, you know, would have that expectation of approximate duration of the operations. And this was something that is in several other subsections, you know, this idea of that notice should include that expectation of duration. So this is more of a kind of a global edit potentially, but this was one specific subsection where it's pertinent.
I would probably turn to Mr. Leonard to opine as to whether they would, you know the duration or have a good understanding of duration.
Mr. Chair, that was exactly what was going through my mind right now. In many cases, I believe they would, because they have their drilling plan. They have their rig contracted. They could, well, and I guess in the other case that I was thinking about, they could do that as well. I was thinking about the cases where they move in and drill a few wells and move out and then come back in and drill a few wells. They'd have to provide that move-in rig up in estimated time every time. I think as long as it was truly an estimate, I don't know why it couldn't be done. Commissioner Gonzalez might be able to speak to that.
Thank you, Mr. Leonard. I would caution about estimates, even non-binding estimates, because the length of time for an operation could vary. Definitely by operator, could vary. Definitely by depth, by length of the lateral, by any number of things, from just the drilling perspective, right? You know, we've seen wells drilled in the DJ Basin, horizontal wells that are 2 miles long. I think the record was like 52 hours, which is, you know, a very short amount of time. But then you could also have a train wreck of an operation, and I say that not above surface or safety issues or anything, but just something operationally goes wrong downhole. You could end up in losing tools in a hole, or, you know, something that could create a delay in how long it takes, where you could be, you know, a tremendous amount off from your estimate, where that expectation may have been set unrealistically, or may have been set without really a true knowledge of the variance that possibly could occur. Right now, if there's going to be an estimate, it's likely going to be like best case scenario. I just don't know how much comfort that will give someone on the receiving end of that estimate, and I don't know how much comfort the operator would have if they're having to put in an estimate and then having to deal with potentially a great variance to that estimate if something changes with the operations. And that's just on the drilling side. Now, on the completion side, you know, every time a completion is done in a basin, and I imagine this is pretty analogous across basins in my experience, is other operators are looking at it. They're using that science. They're using that those results, and they're saying, okay, how is this operator doing it? How is this operator doing it? How's this operator doing it? And they may be changing their completion plans along the way that could additionally change the amount of duration it would take for certain operations. So I think that providing notice of duration is a very challenging target, specifically for operators. I can understand how someone may want an estimate, but if there's a reliance on that estimate, I think there's a danger in that regard as well. I think that it's probably safe for local governments to talk to their operators about that. Same with surface owners. For the general public, I think tables like what was presented by Mr. Andrews earlier today would potentially be helpful to have available to the public on the COGCC website. This is, hey, here's the average right across the state, and you can extrapolate that. This is a pad with 20 wells, you know, 10 days per well, whatever it is. You can make those estimates, but I'd be hesitant to advocate or to really, you know, get on board with having those estimates provided by the operator, either on an MIRU notice or even further earlier in the process, maybe on the 2A. I just don't know that's a good idea.
Thank you, Mr. Gonzalez. Commissioner Najaba, yes.
Thank you, Mr. Chair. And I appreciate that additional information and the expertise that Commissioner Gonzalez is speaking from. I think, though, because this ties to some of the nuisance issues that we just were talking about, if there was a range, and I believe the table that Mr. Andrews presented in some cases provided a range of duration, you know, I'm just thinking about this in terms of the expectation, you know, for the affected, you know, for the building unit owners, tenants, et cetera, in the area. And potentially as it also relates to, you know, any potential wildlife considerations or those kinds of things, if there was a need to, you know, if it was expected to take 14 days, but then it ends up taking, you know, 2 months, that could spill into some different considerations for different receptors. So I'm just trying to, you know, I want us to just think through that in terms of what we could provide, or is there a way that we could do that that at least allows for the expectation? But, you know, I also wouldn't want it to be like, oh, sure, we'll just, you know, say that it's going to take a year just to cover our bases. You know, I would want something that was a little bit of a tighter estimate if we could, just to, again, provide that expectation for those folks in the area or the receptors in the area.
Others desiring to weigh in on this issue? Commissioner McGowan?
Thank you, Mr. Chair. I'm supportive of what Commissioner Nanjapa is trying to put out there, which is kind of, if you're not familiar with what's coming, an expectation of how long something's going to last and what that thing will be like. Not trying to create liability issues, but we are trying to create some more transparency and maybe dialogue. So I'm not sure what that looks like, but I'm supportive of the concept that she's putting out there.
Is there, if we're looking for maybe some middle ground here, I wonder if maybe an estimate may not be the right way, but maybe if an operator can publish or can communicate average drill times or average time from rig up, rig down on maybe a per well basis that could just be extrapolated, could be helpful. That way it's just a representation of data and not a commitment or an expectation setting. I don't know if that would achieve what Commissioner Nanjapa is suggesting, but that's possibly a way to avoid any kind of commitments, binding or otherwise, through an estimate. It just relies on past data and historical data.
Mr. Geronimo just showed up, and I don't know if that means he would like to contribute to the conversation or if he just wanted to say hi.
I'd be happy to contribute to the conversation, and thank you, Chairman. I just want to point out that Rule 309C, which is one of the consultation rules associated with the Form 2A, provides for consultation with building unit owners and tenants within 2,000 feet of a proposed oil and gas location. It's not, it's one of those things that will happen in different formats or depending on whether the people around the oil and gas location even want to engage in that consult. But at that time, the operator is required to provide the date construction is anticipated to begin, the anticipated duration of pad construction, drilling, and completion activities, the types of equipment anticipated to be present on the proposed oil and gas location, and then a discussion about interim and final reclamation obligation. So for the people within close proximity to a proposed oil and gas location, they're getting that information at the time the Form 2A is being considered. Now, certainly, as Commissioner Gonzalez said, plans can certainly change, but the general idea, and I heard you guys talking about, well, can we give them an estimate or a general idea? Our rules already do require that.
Thank you, Mr. Geronimo. Others desiring to weigh in on this topic? Commissioner Gonzalez, I sort of liked where you were going. Maybe it's an either or. If they know the precise timing, they will, or duration, they will say so. And if they don't, then we can attach a card that shows guesstimates or estimates.
And Mr. Chair, a lot of operators are having those types of conversations with the stakeholders before they start operations. At least that's my experience in the DJ, is that a lot of operators are going out, they're answering a bunch of questions. Hey, how long is this going to take? How long am I going to be able to see this? How long am I going to hear this? And so I think there's a lot of places where that information can be found throughout the materials provided by an operator. And if it's already in the 2A, then it's already there. And I feel like that probably settles it for the for the rest of the rules. I don't know you would need to add it to any kind of notice for the move-in rig up if it's already part of the 2A and the public documentation that'd be available through the COGCC website.
Is anyone in disagreement with where this is going? Commissioner Nanjapa, not that you are, you just showed up at the same time I said that.
I'm not in disagreement. I appreciate that additional clarification. I'm still sorting through kind of what we have where in these different pieces of the rules. So appreciate that clarification from Mr. Duranlo, but along the lines of what Mr. Gonzalez was, Commissioner Gonzalez was suggesting is, as I noted, I think Mr. Andrews had a range of timeframes as well. So if not an average, then maybe a range of, approximate, duration that could be expected. Maybe that's also covered in the 2A, but if, again, just thinking through this and other aspects of notice, as operations are getting close to commencing, knowing that the 2A is potentially, quite a duration, quite a long time frame before the actual operations commence, to give a little bit more certainty for what to expect. That's just kind of where my mind is with these ideas. And as I said, there's going to be other pieces in the 400 sections that we're going to be addressing here soon that I also raised this duration idea. And so I'm just thinking more in terms of, as it gets closer to the actual commencement of operations, how can we provide some clarity or certainty? But if the staff feel that is well covered and we don't have issues with that from complaints or et cetera, then perhaps it's not an issue. But it just seemed like that was one of the aspects that related to the nuisance issues and other things that would create a little more certainty for what to expect.
Thank you, Commissioner Nanjapa. Others desiring to weigh in? Director Murphy.
Sure, can I ask, so I think that I've tried to encapsulate some of the direction from the commission and want to make sure that it's correct, because I'm not sure I kind of heard from Commissioner Gonzalez that he's not sure that we should be communicating this, but if we do, we should look towards average drill times or something along those lines in the move-in rig up. And so I guess I'm trying to make sure that I'm correct in thinking that the commissioners want staff to explore how and where we could explore or share anticipated duration, whether it's based on the operator's estimate, the 2A, or an average drill time across the basin. In this particular instance in 412B, and then I think that I tend to infer that the direction that we get on 412B would apply to the other places where a duration estimate would be a helpful piece of information from the commissioners, but I'm a little unclear on what the actual direction is and whether I've captured it correctly.
Commissioner Nanjapa.
Thank you, Mr. Chair. I appreciate that. I think, yeah, I think what you have there, in terms of exploring how to communicate duration and whether we're well covered, whether this has been much of an issue, but again, thinking about it as it relates to these other nuisance issues and that ability to provide a little bit more certain certainty with respect to what to expect as it gets closer to operations commencing. So maybe all that is, I don't know if this would make sense, but just in the notice also including the Form 2A or that kind of information that is provided with the notice. I think I saw, yeah, at least I don't know if that's directly included, but I think what you have there in general in terms of just exploring how you can communicate that, or how to be able to provide a little bit more clarity for how long an operation is going to take, may help address some of these issues and may reduce some of the nuisance related complaints. Does that help?
It helps me with your perspective, yes. I just want to make sure that there's something close to most commissioners agreeing that this is the right tact.
What do others believe? Commissioner Gonzalez.
Yeah, so one comment about kind of, using this notice as a way to update more realistic time frame for drilling or completion operations, specifically for drilling, because we're talking about rig up notice, is is that in my experience, it takes a long time for established basins, and I'm using established basins as a distinguisher, to really see any kind of changes over time when they've been drilling these wells for so long. Now, there are technological advances. There are advances in drilling techniques, in efficiencies, in kind of using the same rig crew, understanding the right way of doing things, and perhaps there's efficiencies to be gained where wells may be accelerated. But in terms of downhole delays or anything like that, those are unknown. And I would say that for the most part, you're not going to see a lot of change over 2 to 3 years in a basin like the DJ Basin. Now, that would be very different if you think about maybe an exploration area where there's only a handful of wells drilled, maybe a handful of wells drilled even in an established basin, but in a different formation. That's when operators are more in the learning experience, well, kind of always in the learning phase of things. But it's where they're really starting to see, kind of those more impactful deltas in the operations. But there's diminishing returns, right? So the more you do it, the less of a change you're going to receive, or you're going to see on the back end of it. So I think it distinguishes based on where you're drilling. But if you're drilling Codell or Niobrara wells in the DJ Basin, you're going to get better at doing it, and you're going to get faster at doing it. But whether or not you're going to get substantially better or faster between when you file your 2A and when you actually submit this MIRU notice, is going to be unlikely to see a big change like that. In that case, I would say if it's already in the 2A, I'd rely on the 2A. And if perhaps even a requirement of the notice or maybe part of the staff's guidance that you included what was in the 2A or those estimates as part of notice, so long as it's not redundant and is not burdensome, kind of from an efficiency perspective, I don't see a ton of harm in communicating it that way. So my direction to staff, or my recommendation is, if it's already in the 2A, I think the 2A provides the baseline information for all these subsequent notices.
Commissioner Messner.
Thank you, Mr. Chair. And I appreciate the conversation that's occurring here. And I think the philosophical conversation that's being had here is whether we want to preemptively and proactively try to address future complaints or impacts to folks that are surrounding these operations. And I think it's been clearly indicated by most of the parties that one of the more impactful operations is the drilling and completion portions of this. And it's also been clearly indicated to me over and over again that it can take 2 to 3 years between the submittal of the 2A and the actual operation to happen on the ground. There, particularly with the residential market that we're in right now, that house could have turned over 3 times at that point. And so while initially on the 2A, that building owner, that tenant, or that residence may have been notified that there was going to be an operation happening within the vicinity, when the actual rig shows up on site, if we're not providing that notice, then they may or may not, it's just going to inevitably potentially cause a complaint. So I think this is just really an attempt to proactively preempt some of the complaints that may be seen, because we're being transparent in the information that we're providing. And it's also important to note that the burden on this is not on the COGCC, but rather on the operator, in order to be able to provide this information to minimize conflict. And so I see where the other commissioners are going on this, and it makes some sense to me.
Thank you for that wrap up, Commissioner Messner. I tend to agree. And maybe what, Commissioner Gonzalez, I know that maybe you're still thinking the 2A is sufficient. I would sort of direct staff perhaps to work on this a bit. And when you get back to us with 400, see if there are opportunities that you've been able to develop. Commissioner Gonzalez.
Yeah, Mr. Chair, thank you. I will. I'll kind of let put this on notice that I really don't think this is a huge deal one way or another, whether it's in the MIRU or not. I think there's so much consultation that's required and that's already going on with the community that the operators should be prepared to field those types of questions and to bring them in. And, you know, if they're concerned about estimates or whatever, as I share that concern, I think it's a valid concern. You know, they've got attorneys to draft this up the right way to make sure that they're covered. So this is, you know, for lack of a better phrase, this is not a hill that I'm dying on, but I think it's important that we address that concern, or at least acknowledge the concern of how estimates are interpreted and relied on in various instances, including this one. So I've kind of said my piece on that. I don't know if this warrants any further discussion or further debate on my end. So that's my 2 cents.
Okay, I think we have given appropriate direction on that issue. Director Murphy?
Thanks. Yeah, Commissioner Messer, not to put you on the spot, but were you able to? Great.
So not Rule 420, although I very much appreciate Braden Heads. The rule that I was talking about was Rule 436, which was in the seismic activity, and some comments around, and Mr. Leonard is giggling as I say this, how we notice wildlife about seismic activities. But in all seriousness, do we need to provide notice to CPW upon commencement of these seismic activities, understanding that in the 300 series, there's the opportunity for CPW to consult, but understanding there's some timeframes between when that 300 series permit was granted and when operations may actually occur, and potentially different things may be happening on the ground that may be a good idea to give a heads up to CPW to see if there's any additional things that need to be considered before operations commence. That's my understanding of the issue.
Maybe turning to staff here for response.
Mr. Minor or Mr. Andrews? Maybe the best folks to.
If I may, Mr. Chair, I think that perhaps Mr. Leonard's team or perhaps even Ms. Stanzik would be the best person to answer this question. Ms. Stanzik is sort of very familiar with the permitting process, which goes more into the 300 series. Mr. Leonard's team, I believe, does have some oversight over the actual seismic operations when they occur, so they might be better equipped to answer this one.
And I do think this is particular, not for the seismic activity that's going to be happening in Thornton with the trucks going down the street, but more for the impacts that could be happening in the more rural parts of the state, where some of these operations do require helicopters and you know, more potentially impactful operations than just the vibrosis trucks.
Mr. Toronto?
Yeah, thanks, Chairman. So COGCC does require a map with the seismic permit, the Form 20, that would include high priority habitat. Our staff reviews the seismic permit. There is no formal consultation built into our rules with CPW on that. But you know, that we could certainly engage CPW during that permit review.
And Chair, if I may, it would probably be appropriate for us to check in with CPW generally about whether this is a place where they want to participate also. And so we could put this in the bucket of let staff work on it a little bit maybe.
And I also should say that there is built in, I don't see that it is formal consultation with CPW, but the seismic permit also includes any plan or measures to protect and minimize impacts to wildlife resources developed in coordination with CPW.
Thank you, Mr. Giralamo. Commissioner Messner?
No, I mean, I do think that seismic activities have the opportunity to be impactful to wildlife. I do think that having that consultation phase, both at the permit level and at the perhaps a notice or a heads up at the implementation level makes some sense, although certainly I'd give the discretion to staff to take a look at it and see if it's not already covered, or to provide an argument, you know, that no additional pieces need to be included. But so I'm not putting you on the spot, but this is something that was brought up, and I do think that it's potentially an important topic.
Commissioner Nanjapa.
Thank you, Mr. Chair. Yeah, I agree, and I'm really glad that Commissioner Messner was able to find this this reference that he had in his notes, because I also had it in my notes, and somehow I did not also communicate this piece to Director Murphy when we were sending our different issues. But this is something, you know, that came up earlier in our conversation on this series, and I agree with Commissioner Messner. I think, and in particular, as I think we noted previously, was that, you know, in the permit phase, and when the Form 2A is provided and that consultation, et cetera, occurs, you know, that's a little bit of a bigger picture consideration of the wildlife and the issues going on. But at the time that the operations are going to commence, there could be new or different considerations. And so, as Commissioner Messner mentioned, you know, if this is already covered in some other piece, that's great, but I just want to make sure that we have some way to address the sort of immediate concerns that may come into play as an operation is about to commence, and especially as it relates to wildlife.
Commissioner Messner, do you have any further follow-up here? Are you comfortable with the direction that Julie has received?
Good.
All right. It appears that we have taken care of the issues on this slide. Is that right, Director Murphy? So we'll move to 411. And we have 28 minutes before we're to hear from Ms. Richardson. Do you want to set the stage on 411?
I would love to. And also, I would ask the commission for direction about, I assume, taking a break. I don't know if we want to take a break before Ms. Richardson's presentation or after, but I suspect one would be appropriate. And if it's before, if we're honoring the 15 minutes, we should try to be prepared to break from this in about 13 minutes. And I think that's entirely doable, because what I would suggest is what I closed with yesterday on this, in that we have made excellent progress on 411, I think, with our stakeholders. I think it was clear that folks had moved kind of down in the tiers of importance of their issues. And I think that we can continue to make good progress on a number of these topics. I think that your questions frame where your thinking is. If you wanted to provide a little bit more granular direction or specifics, I would be happy to take it. But I am committed to continuing to work on this issue with the folks who've really engaged on it, and with our partners at DWR, if appropriate, and definitely our partners at CDPHE. So we did have a follow-up call with CDPHE yesterday, and I don't know if Commissioner Putnam is available right now or if he wants to chime in, but all that to say, we're continuing to work really hard on this. I think the idea of Chair Robbins to lock a couple people in a room, default included staff, and we're gonna be doing it. So with that, I would say, if you want to take a couple minutes to give us some more guidance, that'd be awesome, but let us go do our work is my real ask.
Commissioners?
Mr. Chair.
Commissioner Putnam.
Thank you very much, Mr. Chair, and thank you, Director Murphy. As Director Murphy indicated, we have been working on the issue, and some of the newer issues that have come up over the last few days, and do have some ideas that I think may be helpful for locking folks into a room and coming out with some sort of resolution. I just wanted to flag a couple of overall observations, especially around some of the conversations that were had about ephemeral streams. I think first and foremost, the state of Colorado very strongly believes in the importance of protecting ephemeral streams. They're covered under our act, they're covered under our regulations, and we are currently in litigation with the federal government to preserve protection of those waters for dredge and fill operations in the state of Colorado, and remain committed to their protection. I think one of the things that's critical here is that the rules that are included in Rule 411 come on top of a comprehensive CDPHE water protection system, and we, regardless of what you do here or we do here, we'll still maintain a comprehensive permitting, protection, enforcement, other sort of program. And so, one of the things that's critical here is that any protections added by 411 fit on top of those protections that we already have here and provide an additional margin of safety for drinking water. And I think in that vein, on the question of ephemeral streams, we've got a few considerations. One is our overarching interest in protecting those streams. But two, I think our sense from a technical perspective that the existing buffer for perennial and intermittent streams, which would capture 1,000 feet on either side of those streams, and therefore a fair amount of the ephemeral stream closest to those streams, is already covered in the proposed rule, and that we believe that that will likely provide protection for the vast majority of cases here. And therefore, the kind of proposed rule on the table probably serves the function of addressing some of the acute spill and other sort of concerns that are intended to be covered under the surface water portions of Rule 411. The second piece, and I think flagged by the GIS availability issue, is just the technical and resource challenge of mapping with precision the distinctions between the intermittent and ephemeral streams and all stream reaches. Right now, we have that on a 1 in 100,000 level, but probably need to get down to USGS maps at 1 in 24,000 scale to fully map that out. That's a technical and resource question that we would need to address if we were going to cover all of those streams. So I think given that, one suggestion that we'd like to throw out for you to consider and for stakeholders to consider would be to maintain a set of rules very similar to what staff put out, that would start with the protection of perennial and intermittent streams, provide the buffers that were provided, but also make clear that those could be adjusted as part of the consultation and part of commission action if there's a showing that for whatever reason for a particular site, that site that may be either on or close to an ephemeral stream and outside of the 1,000-foot buffer that's already included might pose an initial threat or an immediate threat to a public water supply, and that those issues be addressed in those, what I think will be minority of cases, and to deal with those really on the merits of those cases rather than coming up with a one-size-fits-all approach for ephemeral streams, which we think will be technically challenging to get nailed just right. So wanted to kind of put that out there, and then happy to address some of the other questions on this list, but I think those could also be nailed down in some of the stakeholder conversations that we'd certainly participate in.
Thank you, Commissioner Putnam. Do other commissioners want to weigh in on the topics on 411 slide? Commissioner Nanjapa.
Thank you, Mr. Chair. The one I fully appreciate and trust the ability of staff and, you know, with their consultations with the other stakeholders to develop something here to address most of these things. The one issue I just wanted to maybe quickly touch on was the item related to the table in 411 and the chemicals potentially extending statewide, knowing that we have a few local governments that already prohibit those chemicals, and my understanding is that this table was kind of based on what they have already prohibited. So maybe just a little bit of clarification from staff on that, and whether or not you know, there's concerns from other commissioners on that point. I guess my thought is if it's workable in certain local governments, why wouldn't it be workable in other areas? And I'm actually asking that question. So thank you.
Chair, if I may.
Yeah, Director Murphy.
Thanks. Commissioner Nanjapa, that is an excellent flag, and it kind of got subsumed in some of these bigger picture conversations around 411. I know that we gave industry a little bit of homework on this topic yesterday, and
Right.
It might be appropriate, and I did have Mr. Neslin reach out to me this morning to say that they were ready and prepared. So if we could find Mr. Neslin in the meeting and see if he has feedback on this topic, that'd be eminently helpful in my estimation.
I think that's a good idea. Seeing other commissioners nodding. So yeah, if we could find Mr. Neslin and bring him to the panel. I see you, Mr. Neslin, at the bottom of the panel. I think you need to unmute.
Good afternoon, commissioners. Can you hear me?
We can hear you. Thank you.
Very well. Thank you. It's a pleasure to be with you again. You gave us a couple of homework assignments. We've done our best to answer them. I've spoken with most of the industry parties, not all of them. Also spoken with the trade associations, API, KOGA, and West Slope KOGA. First question was, the table lists 23 chemicals by CAS number, which may not be used as additives in hydraulic fracturing fluid. And this prohibition applies to intermediate buffer zones of surface water supply areas and goody wells. You ask whether this could be extended statewide. We can agree as of right now with respect to 22 of the 23 chemicals. There's one chemical, polysorbate 80, CAS number 9005-65-6, which has recently been used by some operators. We're investigating that use to see whether there is a need for it to continue, under what circumstances it was used, whether they're replacement chemicals. And we'd like to report back to you with respect to that one chemical, probably Tuesday, and answer you further on that. With respect to the other 22 chemicals, the industry agrees that that prohibition can be extended statewide. We'd like to clarify and confirm that we're just talking about a prohibition on the use of these chemicals as an additive in hydraulic fracturing fluids, and that this wouldn't restrict the reuse or recycling of water that may have trace amounts of the chemicals. And we know there's a little bit of language to that effect in 411. We would like to suggest some further language for the rule and the statement of basis and purpose to clarify that point. The second question you asked us was whether the standards for goody wells in Rule 411B2 should also apply to type 3 aquifer wells under 411C. And again, I can report that the industry parties that I've been able to caucus with support extending those standards to type 3 aquifer wells as well.
Thank you, Mr. Neslin. Are there questions for Mr. Neslin? Mr. Messner, please.
Yeah, no question from me. I just want to say thank you to Mr. Neslin for such a quick turnaround on that. I think those are very important issues, and I think this is going to help us get to some consensus on some of these, which is excellent. So cheers to you guys, and thank you very much for the quick turnaround and all the efforts associated with, I'm sure, a lot of phone calls and contacts. So thank you, Mr. Neslin.
Commissioner Messner.
Darn it, Commissioner Gonzalez, you got there before I did, but I do want to thank you as well. I appreciate the quick turnaround and obviously a lot of phone calls you made in order to get that response. So thank you very much.
Thank you, commissioners. I think like you, we trust and hope this will lead to stronger and better rules. So thank you.
Do commissioners have further feedback? I think we've done a fairly good job at this point on this slide. And I know that there are still folks locking themselves in rooms to try to work this out. I'm comfortable with the direction that you have now, Director Murphy. Is everyone else? All right, thumbs up all the way around. It is 2:16. Do we want to take a break before our hour-long set-aside with Ms. Richardson? Seeing a yes, let's return at 2:30. The Colorado Oil and Gas Conservation Commission rulemaking. We are going to put our deliberations on the 400 series on pause for the next hour or so. And we have with us Christy Richardson with CDPHE. Good to have you, Ms. Richardson. Thanks for being here to present to us. You had presented to the interim commission, I think a similar presentation a while back. So Commissioner Messner and I have heard this. It's important information and we're glad to have you back. And just for our stakeholders, folks, we originally tentatively had this scheduled a week or two ago, but that was before we had actually started the formal rulemaking, and we wanted to schedule this at a more appropriate time, which is now during our rulemaking. And so with that, Ms. Richardson, if you would unmute yourself, introduce yourself, and provide us with your presentation. Thank you.
Thanks, Commissioner Robbins. Hi, everyone. My name is Christy Richardson. I am the state toxicologist with the Colorado Department of Public Health and Environment, and I'm hopeful that you all can see my slides now. So thanks for having me here today, Commissioners. I wanted to just talk with you about current research on the health impacts of oil and gas development. We'll talk a little bit let's see, here we go. We'll talk a little bit about how we understand health risks, both from a toxicological and epidemiological perspective. And I'll talk about what those words mean too. And then we'll talk a little bit about how we use measurements of ambient air, as well as models, to really understand what those health risks might be. And then I also just wanted to touch on what we don't know. Even based on all of the information that we've been collecting so far and that other researchers have been collecting. So first, I really want to talk about, this framework that we have up on the screen talks about how we assess human health risk from oil and gas operations. So if we think about an operation, a source, it doesn't mean anything to us from a health risk perspective unless something's leaving that source and people could be exposed to it. So the main way you could be exposed to chemicals or pollutants from oil and gas is primarily through the air. There's also some possibility of exposure through surface water or groundwater or soil, but this is much less likely under normal conditions at an oil and gas site. And so we see emissions coming from the site. And then, whether or not you're exposed to those emissions depends on really that concentration that might reach you, as well as various factors that could affect your exposure. So we could think about whether you're inside of a car or outside of a car, or inside of your house with an HVAC system going, or outside on your back porch. And then it also is going to, the distance that you are from the oil and gas operation, the weather conditions, and then the specific activities at the oil and gas site could all factor into how much is released or emitted from the site, and then how much you might be exposed to. And then from a biochemical perspective, what really matters is not just how much you're being exposed to, but how much reaches the different places in your body where that chemical could cause toxicity. So for instance, if we talk about benzene, which is one of the chemicals we're most concerned about in oil and gas operations, we are really interested in how much benzene might reach your bone marrow and interfere with the development of bones, of blood cells in your bone marrow. And then in terms of those health risks, right? So we talked about how the dose of how much gets to the person or how much gets to that place in your body where it could cause toxicity. But really, when we think about how we understand those health risks, we use 3 different mechanisms. We can use toxicity studies, epidemiological studies, and then both exposure measurements and modeling. And I want to talk a bit about the benefits and limitations of these 3 approaches, and sort of understand what we know and what we don't know about these, and hopefully address some of the questions that I've heard either from commissioners or from various stakeholders in the documents that they've submitted. So toxicity studies, this is really the bread and butter of how we understand health risks. And these are laboratory controlled studies where we take laboratory animals, most of the time we're talking about rats, and we expose them to different chemicals. And we do this in a very controlled atmosphere. So we know every different factor of that animal's life. We even control for the genetics of the animal. So we know that the effects that we see from those different doses of chemicals that we give them are related to the chemical, and they're not related to something else like the type of food the rat ate or other chemicals that are in the air. So we control all of those things, but we're really limited on what chemicals we can study. It gets exorbitantly expensive, the number of chemicals and the number of doses you use. We also, want to make sure that the outcomes that we're studying make sense, right? We use a lot of scientific modeling and information from other chemicals to say, this new chemical might cause these certain health impacts, and we want to really study those and focus in on those. But also because we're talking about animals, we can't always measure the same endpoints that people complain about. So one of the things we hear about often from people who live near operations is that they get headaches. And it's really hard to understand whether a rat has a headache or not. You can imagine maybe we could do a study where we have little rat sensors where we are doing MRIs on all of the rats, and could maybe see some changes related to headaches. But it's really hard to get at all of those different outcomes that people might experience, where we have a lot of sort of subjective nature in terms of the pain. It's much easier to say that a chemical causes cancer to develop because you can see the cancer very easily. And what's really important about these health studies is that we get quantitative dose response data. So this tells us that X concentration could cause Y effect. And it's really important here to think about this concept because it's not just what you're exposed to. It's not just that you're exposed to benzene, but at what level you're exposed to benzene that really matters. you can see from this chart here where I've got water, ethanol, caffeine, nicotine, and then arsenic and Botox. So some of those things are notorious for being toxic, but some of those things like water, right, are things that we think of as really good for us. But it's really how much of that substance that makes a difference. You could drink 3 gallons of water right now during this presentation, and it could cause really damaging effects to your kidneys. It could even kill you. So when we think about these health risks, we have to understand not just what chemicals are there that you're being exposed to, but at what levels you're being exposed. We also use epidemiological studies to try to understand health risks. And we hear a lot about these. There's quite a few researchers in the state of Colorado at the School of Public Health and others that do this type of research, where we're trying to look at a population of people that live near oil and gas operations or other operations. And we're really trying to look at health effects across that population and evaluate how they're connected to exposures, what the distances are, you know, how we might see those relationships. Do we have higher rates of, say, asthma for people living near roadways where we have more pollution than people who live further away from roadways? But these studies are really difficult for us to use from a risk perspective because you can't control a person like you can control an animal in a laboratory setting. People are exposed to many different things. I'm sure we all had different things for breakfast and lunch today. And all of those different sort of lifestyle factors and dietary factors and then genetics all play into what sort of health outcomes we might experience. And then sort of the higher tier studies like where we can develop case controls, or we can compare 2 people who are really similar and try to control for a lot of those things that we would control for in a laboratory setting, like their diet or, you know, whether or not they're a smoker, things like that, become really difficult. You need to have a lot of people enrolled, and therefore they are very, very expensive. And then sometimes the effects that we see from chemicals can be related to not just the people that are exposed, but to their child or even their grandchild. And with people, you know, we would have to be studying oil and gas for, you know, about 60 years to really be able to get at that sort of information. So they do have the strength in sort of pointing us towards areas that we need to further study. And they do help us to better understand sort of the places that we might want to conduct further research, or the chemicals that we might want to better understand their dose response, and what that threshold might be for health effects. Recently, there was a review of epidemiological studies related to oil and gas development. We looked at 20 epidemiological studies, and that included 32 different health outcomes. And we found limited evidence of harmful health effects. We see asthma exacerbation, it makes asthma worse for people. And we see a variety of different self-reported symptoms like headaches and dizziness, stress, skin conditions, things like that. And, you know, I think when we look at this, we look at all this evidence and we say, okay, well, it's limited and we need additional high quality studies to be conducted. But, you know, I think the challenge with that is that these really high bar studies, there are things like randomized control trials. They might not even be possible in this setting. They're, like I said earlier, they're expensive and they're difficult to conduct. And it's not surprising that we would find limited evidence. I think that limited evidence in sort of the scientific epidemiological world has a bit different connotation, just like scientific theory has a different connotation to the general public than it does in the science realm. I think we see that these low levels of certainties are sort of as a starting point. They help us to better understand where we should focus more research. The observational studies that we use point to places where we need to get more research, but having limited outcome from epidemiological studies is pretty normal because it takes a long time. For cigarettes, for instance, I think everybody hopefully knows by now that cigarettes are bad for you. But that took about 40 to 50 years of research, of epidemiological research, to really be able to say that conclusively. So we're still building that body of evidence, and we're trying to understand where it should steer our further research. So we take all of this information that we get from these epidemiological studies, from occupational health studies that are a lot like epidemiological studies, but they have a more controlled setting because we can better understand those exposures in a workplace than at multiple places across a county or a state. So we take all this information and we try to pull it together and come up with a threshold for what might be a reasonably safe exposure, right? So we call these health-based guideline values, and these are set to be protective of human health to provide a reasonable amount of certainty that if you're exposed below that level, we think that you're safe. The health guideline values that we have at CDPHE come from both animal and human studies on exposure to individual chemicals. Shown here is just some of the studies that have been done for benzene. And we use all of that information and then we apply what we call uncertainty factors. So you can see here that we have a bunch of dots representing individual studies. And then at the bottom of the screen, we have a line that indicates the acute benzene minimum risk level, or where we're setting our health guideline value for benzene. And there's a pretty big difference between where we see those health impacts and where we put that health guideline value. And we do that to account for things that we don't know, to make sure that we're protecting sensitive subpopulations like young children or the asthmatic, people that may not have been studied comprehensively in all of those individual different points. And for CDPHE, when we derive these health-based guideline values, we're using guideline values. Here we have the ATSDR minimum risk level that are derived from all of these toxicity studies and epidemiological studies, but this sort of process where we take all of the studies together and whittle them down to one number or one line in the sand is done primarily on the federal level. We have a couple agencies, both EPA and ATSDR, which is the Agency for Toxic Substances and Disease Registry, do a great job of providing these numbers to use for risk assessment and understanding human health risk. We also have some state agencies like California and Texas that produce these numbers. And we rely on those numbers that are produced by other agencies. We don't have the resources here in our state to derive those numbers. And we pick our numbers based on sort of the agencies that we think have put in the best sort of scientific rigor into deriving those health guideline values. And I think that you all may have heard or read about some talk about different numbers that are out there. And so I just wanted to touch on, right now, CDPHE is using this benzene minimum risk level for acute exposures of 9 parts per billion, and that comes from the federal agency ATSDR. But we also know that there's a California number out there, and that's 8 parts per billion. But while those numbers if you just compare 8 and 9, you know, my children can tell you one is bigger than the other. But if we look at those numbers and compare them to all of those studies where we see either the lowest level of health effects or no health effects in studies, we can see that we're still well below those levels. So overall, we're trying to take the best available information to tell us what's a reasonably safe exposure, right? So we think, based on the best available science right now, that ATSDR 9 parts per billion for a short-term benzene exposure is the appropriate health guideline value. But it's also important to keep in mind that exposure time really matters for understanding health risks. So I use the words acute and short-term. And we really need to take that into context when we think about these. So if you look at the graph at the bottom of the screen, we have just the time of an oil and gas operation on the x-axis, and then we have the amount of pollution on the y-axis, and we have an orange line that shows varying concentrations. We see that levels are really different depending on what's going on in the operation, and we see quite a bit of variability in those levels. And so we have to really think about this. If we think about the average exposure over a long period of time, when we think about chronic health impacts, it's really appropriate to think about that average over a long time. And what does that look like? Overall, what are you being exposed to, and what health risk might be associated with that long-term exposure? But when we start trying to drill down into those acute or short-term health impacts, things like headaches, or things like nosebleeds, or other health impacts that happen to people but then go away, and we're really thinking about exposures that are not over a year or many years. We're thinking about exposures that are up to 14 days. And if you start drilling in finer on my graph at the bottom, that big peak, right, that could be a day or two. And looking at that concentration that you see, the average for that peak, it would be much higher than that annual overall exposure. And I think this really plays into how we collect information, and why we need to collect different types of information, and why we need to collect data that has a really fine scale that lets us understand where those peaks might happen and how long those peaks might happen, but then also trying to understand over the lifetime of a well what that average exposure looks like, so we can understand those longer health risks. So now I want to talk a little bit about how we use measurements and modeling exposures to give us more information about what those health risks look like. So we can conduct a sort of screening level risk assessment. We do a lot of that here in the state, where we measure the concentrations, and basically we just assume that the concentrations in someone's neighborhood represent their exposure concentrations, and try to understand whether those exposures in a community are above or below those health-based guideline values. And we also are going to talk a little bit about our modeling study that we released last year, where we really looked at the rate of emissions. So how much is coming from an oil and gas well pad, and then use that information to model concentrations and exposures, and then use that to better understand health risks. So it's two different ways of going about it, either measuring levels in the community or using the data that tells us how much is coming from a well pad to get at really what those health risks might be. So, first I should talk about the Oil and Gas Health Information Response Program released in 2017, an assessment of potential health effects from oil and gas operations in Colorado. And we looked at all of the data that we could find for the state of Colorado from various researchers throughout the state. and really try to look at how people might be exposed based on that data that we had. And there we looked at about 10,000 air samples. And for that assessment, we found that all values were below those health-based guideline values, right? So we didn't see any instances in the data that had been collected thus far in 2017 that were, you know, raising the alarm bells for us. But, you know, I think we understood that we had a limited data set and it might not adequately represent community exposure. So our Oil and Gas Health Information Response Program operates the mobile Colorado Air Monitoring Mobile Lab, the CAML, which you can see in the picture down below. And that mobile lab really acts as a proxy for a community member. We go and park it in a community and it collects data on a short time scale, and then we can average it out over a long time scale to better understand both acute and chronic risks. And we use that data to do those screening level risk assessments where we're just comparing the concentrations to those health guideline values. And to date, we've collected about 7,000 hours of air samples near oil and gas operations from about 8 or 9 operations throughout the state. And we've had only one 1-hour sample that exceeded the acute health-based guideline value for benzene. But I should also point out that when we do measurements, we're always limited by the fact that we can only collect measurements at one place or maybe, you know, a handful of places if we have some sophisticated information. We can't collect data about the exposure for every single community member or every community in every direction around a well pad. And we're always limited by the data that we collect. In the science lab that they portray on the television, you can take them any kind of sample. You could take them a hair sample or a poison sample or a water sample or a soil sample and give it to the lab analyst, and they stick it in the magic machine, and then poof, you know the DNA of the person who dropped that piece of lint, right? I mean, they can answer anything, but it's not like that in a real scientific laboratory setting. And the vast majority of the time, you need to know what you're looking for so that you can quantitate or actually measure what you're seeing. So we're limited in that we only normally measure between 20 and 60 VOCs in those studies. I also want to talk about the modeling study because this is where we tried to do the most comprehensive risk assessment to date in the state of Colorado. When this study was released last year, it was the first study of its kind where we really pinpointed sources in both in Garfield County and the Northern Front Range to understand sort of both of the major basins in Colorado. And we looked at multiple phases of pre-production or development and then production. And we looked at different well pad sizes. So a well pad that had 1 well up to a well pad that had 32 different wells on it. And we measured the emission rate. So the mass per time that was coming off of those well pads. We then used some air modeling, or AirMod, which is a computer program that allows us to take that emission data and model it out to different concentrations. So we looked at concentrations 300 to 2,000 feet from the well pad center. And we tried to look at the potential for short-term health effects by looking at 1-hour maximum exposures. What's that worst case scenario that takes into account both the peak emissions that we measured from the different well pads and also unfavorable meteorological conditions. You could think about sort of being on a road that's in a depression with stagnant air so that you might get the sort of highest exposure concentrations. And then we also looked at sort of longer term health effects by looking at average exposures from 14 months, so just over a year, to 30 years. And that really focused in on the longer development operations like flowback, and then also production. For the acute, we really focused in on the activities that happen for shorter periods of time. So we were looking at pre-production, drilling, fracking, and flowback. And then we use those concentrations at different distances around the well pad, and then ran them through another model to better understand the inhalation exposure. And that really takes into account your micro-location. So are you inside your house with your windows closed, or are you outside on your back porch, breathing rates and things like that, to really get a handle on how people might be exposed. The one thing I should point out this model didn't do is that it didn't calculate how often we might be exposed to those worst case scenarios that we use to model. But when we did this modeling, we took those exposure doses that we might see for different people at different distances, and then we assessed them against health-based guideline values. We modeled risk of short-term negative health effects. And again, that's during those worst case weather and emission conditions that we don't know how often they occur. The risk was highest for flowback, but we also saw risk related to drilling and fracking activities. The chemicals that were driving the risk were benzene, toluene, and ethyl toluenes. They're some of the chemicals that we almost always measure related to oil and gas operations, the BTEX compounds. And while the risk was different, it decreased the further away you got from the well pad. We did see a risk, an acute health risk, at all distances that we modeled from 300 to 2,000 feet. The model also looked at these longer term health risks, and it showed a low long-term health risk. We saw a slightly elevated risk of blood and nervous system effects at 500 feet, but not by the time you got to 2,000 feet. And I should point out that when we think about the blood and nervous system effects, that's when we're taking all of the different chemicals that we measured that might cause blood effects or nervous system effects, and we add them all together. But the risk was pretty low, especially when you compare it to those acute health risks. We looked at the cancer risk too. We look at cancer risk in a little bit different way, and I'm happy to answer questions about that if we want to talk about that. But that all was within sort of EPA's acceptable risk range. But we did not assess the cumulative long-term effects in areas that have multiple well pads. So if you think about a community where we might have well pads to the north and to the east, say, we didn't look at what the long-term exposure might be to a community member that's being exposed from both of those well pads. So I think all of this research together has given us a lot of direction in terms of what we know and where we might need to go. I think we have learned that there may be a health risk under certain weather conditions. The data that we have so far tells us that it probably doesn't happen very often, but we really should understand how frequently that might occur and whether that might occur differently depending on different operations at a well pad. We saw highest risk associated with flowback, for instance, but we also still saw lots of variability in the emissions during flowback. And I think we really need to get a better handle on that variability and what specific activities, not just that we're doing flowback, but we're moving tanks around, or we're doing some specific activity that might be related to those peaking emissions. Because if we can understand that better, then we can find touch points where we could regulate and minimize those emissions. We also don't have toxicity information for really short-term exposures, generally speaking. anything less than 1 hour is not easily comparable to toxicity data. And yet those are the types of exposures that might be associated with the symptoms that people frequently report to us, things like itchy eyes, headaches, nosebleeds, things like that. And we just don't have a good way to even get that toxicity information. We also are always limited by the sort of research design that we set out and how we frame their study questions. We know from studies in fracking fluids that or fracking fluids in produced waters, that there's over 1,000 chemicals that have been detected in those fluids. And we don't have a really comprehensive evaluation of what might be emitted into the air. We know what the major compounds are, and that's what we've always been working towards addressing, these VOCs, these substances like benzene and ethyltoluene. But when we don't know all of the chemicals, it makes it especially hard for us to think about the mixtures of chemicals and what those health impacts might look like. We try to address that by thinking about all the chemicals that could cause blood impacts or nervous system impacts or could all affect the same organ system, and try to look at that together. But if we are missing some key substance, then we might be missing a big piece of the puzzle and not really assessing that adequately. I think the study tried to look at those longer term health effects, but when you start thinking about cumulative exposure from multiple well pads and really thinking about what people's background exposure might be, I think we have a lot of work to do there to get a better handle on what that looks like. And then, we don't have a really great handle on the cumulative impacts of not only chemical exposures, but the noise, vibration, truck traffic, all of that stress can complicate or exacerbate health symptoms. And we don't have a really great quantitative way to address all of that. So we're doing our best to try to better understand those health impacts, because we know people are concerned about their health, and it's stressful to live near oil and gas operations sometimes because it's noisy and it's smelly and your skyline doesn't look the same anymore. But we're also trying to make sure that we're using the best available science to steer our recommendations. And so we're continuing to evaluate the science and to gather new information to help define the areas that we need to focus on. I think, we're really hopeful that the information gathered from COGCC's cumulative impacts rule, as well as the AQCC's various rulemakings, will help us to better understand the potential health risks and to really get a better handle on how we can address the cumulative impacts. And so before I go, I just wanted to point out that, when we talk about health risks, that risk assessment, which is driven by science, is only one part of the picture. Risk assessment is really a systematic process for us to describe and estimate the likelihood that somebody's health might be impacted from environmental exposures from those emissions from oil and gas. And we take into account the levels of exposure, the concentrations that we measure or model that people might be exposed to, and the information that we have about the toxicity of those substances. This feeds into risk characterization, which is the information we try to provide to the COGCC and the AQCC so that they can have a science-driven regulatory process. But there's always still more questions about those health impacts and the risks to people. Policymakers are often charged with a really difficult task of using that science that might not have all of the answers, right? That risk characterization, and then taking into account how they make their decisions on acceptable risk levels. What's acceptable? Is it acceptable for one person to get a nosebleed for no people to get a nosebleed, or for cancer, for one person to get cancer in 1 million, in 1 trillion, in 10,000. You know, I think those are all things that we have to consider. Also, there's always going to be imperfect mitigation options. We could work with our research partners to further identify more emission points and more activities that might be related to fugitive emissions. But, you know, the mitigation options might not always be the perfect solution. And then, you know, I think I'm sure you all as commissioners are aware that there's limitations to regulatory authority. And, you know, I think from the public perspective, one of the things that I find most challenging is that people want no exposure to chemicals. And that's not possible. I mean, everything is made of chemicals. And as I said at the beginning, it's really that dose, how much you're exposed to and for how long, that really is going to determine whether or not there are negative health impacts. And so, you know, I think we have to try to manage all of that and really understand what's driving the risk and where we can have more impact to minimize that risk and reduce the potential health impacts to the people of Colorado. So I wanted to make sure that we had some time to have a discussion with the commissioners, and so that you all could ask me any questions you might have. I'm hopeful that this presentation provided you with an overview, not just of the risk assessment study that was released last fall and that I presented to the interim commission, but a broader picture of the work that we try to do to better understand the potential health impacts related to oil and gas development. So thank you.
Thank you, Ms. Richardson, for the presentation. That is good information for us to consider. And thank you for making yourself available for questions. We have our commissioners in the house, and they've all turned their video back on. I think we're all listening to you and taking a break from being videoed all day long, every day. So with that, I would turn to commissioners for questions. Commissioner McGowan.
Chair. Hi, Christy. I am wondering if you could explain to folks, I think that some folks have mentioned that some people have looked at CDPHE's data around Bella Romera, and where you mentioned that we saw one 1 hour window where we saw an elevated health risk, I think related to benzene. And someone else has looked at our data and said, no, in fact, there have been many more. I'm just wondering if you could explain the difference and why someone else is looking at the data a little differently.
Yeah, sure. It's good to see you again. So, you know, I think this really harkens to what I talked about earlier related to that frequency and the duration of the exposure. So if you look at perhaps data where we see this, the different health guideline values that are set up for acute and chronic, right? So if we look at our 1 hour measurements, about 1 hour measurements that we take, and we count the number that are above the chronic health guideline value, we would find a number that's pretty close to what others have said. But that's not appropriate, because a chronic health guideline value is supposed to think you're looking at the long-term health risks over a long period of time. And so you can't take each individual hour and compare that to a health guideline value that's protecting you from a health impact that takes a long time to develop and takes a long duration of exposure to develop. Also, I think there's some disagreement between which health guideline value which one we use. And so, you know, we use the ATSDR, the Agency for Toxic Substances and Disease Registry number. and we really think that this is the most appropriate number. The ATSDR goes through a very scientific, rigorous process to derive that number. And the other number that's being used is this 8-hour number for California, which is, or sorry, this 8 part per billion number for California, which is a little bit lower. So if you count the number of exceedances for that, you get a few more hours that are above that. But you know, the California number is ultra protective. Like, I would say that ATSDR's number is protective. The uncertainty factors that California uses are a little bit they're non-standard. They aren't what we would use in a standard toxicological review. They don't follow sort of the standard conventions and the guidance that are sort of the way that we do things in toxicology. And then, you know, I think California also thinks about a school exposure. So they take their long-term chronic number and they say that an 8-hour exposure for children should be the same thing, because we don't know enough about the way that benzene causes toxicity to understand if repeated 8-hour exposures are the same as this longer term exposure. But you know, when we look at the data, when you look at California, the way that California derives the 8-hour number, they're talking about repeated 8-hour exposures. So we're really thinking about children during every school day, or we're thinking about workers every work day. And we don't really see that scenario where we have, you know, a whole week of 8-hour exposures. We see, you know, an 8-hour exposure during this week or in the evening, and then, you know, halfway through the day the next day. So we're not seeing that sort of repeated pattern where we would think that we would see students for that long period of time. So overall, I think it's some discrepancy in sort of how we assess the data and the numbers that we use to assess the data. And I think, you know, that's really why it's important to think about not just what health guideline value you're using, but also that magnitude and duration of exposure, and make sure that the health guideline value and the data that you have are aligning. And I think that's really important too. If you think about just air pollution and from the Air Quality Control Commission and at the federal level too, when we think about how we regulate air pollution, we really are looking at like the mass per year that you release. And for a long-term exposure, that's fine. We can do a lot with that. But when you start trying to think about these acute exposures and thinking about how, you know, 1 hour or 1 day or a couple days of exposure could lead to health impact, we really don't have that information in terms of the data that we collect from a regulatory perspective.
Thank you. Other commissioners with questions? Yes, Commissioner McGowan, please.
Thank you, Mr. Chair. So I wanted to, for folks who are listening, and I've heard this presentation a couple of times, and I'd like to put things into what I call the elevator speech. Like, if I had to explain this study really quickly to somebody, how would I sum it up? And one is, it's the first time that we've used actual air emissions data to put into a model, but we did stick it into a model. We stuck it into data into 2 models, and those models are pretty conservative. They're assuming I'm in the, depending on how you look at it, I'm in the worst location on the worst day with the worst weather conditions with the maximum amount of exposure. And that's how this study looked at that data. And so is it fair to say that we're looking at things pretty conservatively from a very a risk-averse perspective?
Yeah, I think particularly for the acute scenarios, because for the acute, we really looked at those worst 1 hour exposure potential exposures. For the longer term health risks, we tried to just average it out. So, you know, I think that's more appropriate for real life scenarios. But for the model, yeah, the emission data we took. When we modeled that, we took the worst of the worst. What's the worst potential exposure you could have? And then we looked at, okay, if we expose all of these different people to it, what would that look like?
Thank you.
Any further follow-up, Commissioner McGowan?
Not yet.
Okay. Commissioner Gonzalez.
Yes, thank you. Good afternoon, Ms. Richardson. Thank you very much for that presentation. I had a question about kind of that graph that showed kind of the peak in an oil production's life. What was that peak associated with?
So, I think that's a really big question for us. We know that we see higher peaks during flowback, but we also know that all of the different activities that we've measured, we see quite a bit of variability. And so we still don't know if that's just due to peaking emissions and or sort of meteorological conditions. And it's probably a combination of both, right? So some specific activity happens on the well pad, and we don't have any really great quantitative scientific information about that. That's a really large gap that we have. Anecdotally, we hear from people, that it might be related to when they're pulling pipe out of the ground or when they're moving produced water around. And, from a physiochemical perspective, you could think about VOCs want to get into the air, right? And so if you take pipe out of the ground that's covered with oil, you now have tons of surface area that now is allowing all of those VOCs to escape. So maybe that's a plausible time where we have those peaking emissions. But we really don't have a great handle on specifically what's happening when we see those peaks.
So when we talk about emissions, we're not necessarily talking about the result of combustion. We may just be talking about natural or gaseous, whatever particles just being released. So just being emitted into the air. Do I have that right?
Yeah, these chemicals that we're talking about are found within the basin itself, in the oil and gas itself. They can also sometimes be found in various drilling muds, depending on what drilling muds, and I don't know which one you approved and which ones you didn't. But they could be associated with that. And then these chemicals could be related to the burning of fuels as well.
Have there been any mitigations that you see in your study, or at least looked at the equipment, or that other states may have looked at or implemented, that reduce the amount of emissions during activities such as flowback? Like, and I don't know this. I'm not a completions engineer, but I'm curious if you have any idea if there's some sort of containment that exists.
Yeah, Commissioner, I think that's a great question, and we're really trying to identify ways to get a better handle on this. I think the data that we used for our human health risk assessment was collected a few years ago now, and some of the newer technologies weren't available at that time. So we don't even know if that data from that risk assessment are appropriate now. We have seen some different technologies being employed. We see this green completion where they're not doing the sort of on-site flowback. They're taking that directly into the pipeline and separating the water from the oil somewhere else. And while we don't have a really comprehensive comparative study, it does seem like the emission might be lower when we see those greener completions. But, I think we're looking towards our partners and exploring the settlement funds to better understand those things and to better understand to better quantitate the difference between those different technologies. And I'm hopeful that we can, work with our partner agencies to, provide that information as a potential point for either COGCC or AQCC to implement additional regulations.
Thank you. I have one more question, Commissioner Putnam. I'll let you chime in after this. I'm curious. So you mentioned kind of meteorological factors that may or may not influence the study. And I'm curious what kind of meteorological controls were used for the monitoring systems? Were they all done during the same time of year? Were they spread out, across days? And I'm not a meteorologist, but I read the newspaper. I know about ozone days and when it's hot and when air gets trapped over, the front range, kind of how that happens. And if there's any notable difference between the front range results as due to the front range's unique meteorological environment versus the stuff you saw out on the western slope.
So thanks. That's another great question. So again, I should just point out that I'm the toxicologist. I'm not the atmospheric chemist. But based on sort of my understanding of the study, when we do the emissions, when we do the actual emission rate study where we put a tracer gas at the well pad and then measure all of the chemicals plus the tracer gas with the van that Jeff Collette at CSU operates. That's such a small distance that we don't think the meteorological conditions would play an important role. We then take that information and run it through the AirMod model. And when they did that, they used like a year's worth of data. So they try to account for all of those differences in if you have that exact same emission rate every hour of every day for a year, how might that be different? So we tried to account for that, but the project didn't tell us that winter days when there's a low inversion layer in the morning are the worst. It didn't really address that question. That's another great question for us to try to understand.
Thank you.
Mm-hmm.
Commissioner Putnam.
Thank you, Mr. Chair, and thank you, Commissioner Gonzalez, for the great questions. I did want to follow up just a little bit about the emissions controls, that there are a number of very effective emissions controls, many of which are incorporated in AQCC regulations now. Some are proposed in the AQCC rulemaking that'll be happening in a couple weeks. For example, as we learn more emissions that we find associated with produced water facilities, for example, when we learn, we can craft regulations around those to tighten up emissions, included new provisions on well unloading in the rules that AQCC promulgated in last December is being one of those areas. But I think some of the green completions pieces that Dr. Richardson had mentioned are critical, that there are technologies to keep those emissions kind of in a closed loop, closed pipe system. And if you don't release them to the atmosphere, you don't have those emissions. And so, continue to look for those opportunities. And those are a lot of the kind of best management practices that we look at. And I think COGCC is looking at and will be a big part of the kind of way forward here.
Thank you, Commissioner Putnam. Ms. Richardson, did you have a response to that or just acknowledge the statement? We're at 3:26 and we may have some additional questions, and I know that I was informed you have a hard stop at 3:30. Is that still the case?
No, Commissioner Robbins, my hard stop is for a little bit later today, so I can stay for a little bit longer if there are additional questions.
Oh, excellent. Thank you for your time. Additional questions from commissioners? Commissioner Gonzalez.
I'm very curious today. So in regards to, I think the way Commissioner McGowan framed it is kind of, when we're looking at these short-term acute impacts, we're looking at them on kind of like worst case scenarios, like just the opposite of ceteris paribus, right? It's just, well, maybe not the opposite, but whatever. It's the worst case scenarios. And so you're looking at it that way. Is there a way to average it out, to maybe take a more realistic application of the data to the way things work? I mean, it's an ill asked question.
No, thanks, Commissioner, for that question. I think that's a great point. So I think I should point out that typically when we do risk assessment, we try to make sure that we're being protective. We want to make sure that we're really getting a handle on what those exposures might look like and what's reasonable maximum, and is that where we should be protective? I think we try to understand the health risk from that perspective. Whether or not that's where the risk is managed, I think is a policy call. There potentially are some ways to look at the data in other ways, or to reassess the data, or to gather more information to quantitate how often we think that might happen. We probably would need to get some more information on the emissions. When we measured the emissions, we didn't stay at a well pad and measure the emissions every day for years and years and years, right? We took sort of a snapshot. And so there's some gaps there. And then, I think we could then potentially look at not just that maximum modeled concentration over a year under different weather conditions and then different exposure patterns for people, but we could look at the average concentration for 1 hour, or all of the concentrations. And so, with enough computer power and people and resources, nearly anything's possible. But, right now, we don't have that information at hand.
Thanks for the answer.
Mr. Gonzalez, to follow up?
No, that's fine, Mr. Chair. Thank you.
Commissioner McGowan.
Thank you, Mr. Chair. So, we've had this conversation a couple of times, but the decisions that we make are going to be the best that we have at the time that we have them with the data that we have. And so as we head into the 600 series and we all start thinking about setbacks, and I know that's a $64,000 question, I am not going to put you on the spot and ask you what you think it should be, but I do want to talk a little bit about, we've been talking about continually collecting data and error data, and I'm wondering how the department is planning on using that data so that as we learn more and more, how are we going to use it to inform these policy decisions that we're making? And so it could be a question for you, Christy, or sorry, Dr. Richardson, or Commissioner Putnam, but this discussion that we're about to have about setbacks is going to be based, quite honestly, on a limited number of studies and with limited data. And so it's going to be the best decision that we can make at this point in time. And I think a lot of us are looking at the CDPHE study to help inform that decision. But I'm hoping that we can talk a little bit about how we're going to keep hopefully getting real emissions data and how we're going to use it.
Well, thanks for that question, Commissioner. I think maybe I can start broadly and then John can drill down into more specifics about, Commissioner Putnam can drill down into more specifically about what we're going to do. But I think the point that you made about, we're always going to have imperfect science is something that we're living today and every day with the pandemic, right? The science is constantly evolving on the situation, and we're using that to steer our decision making and to provide public health recommendations based not on what we knew yesterday or what we might know tomorrow, but on what we know today. And so, we've seen differing recommendations on masks and social distancing and whether you should get packages from Amazon or not, right? Those are all things that have evolved as we've gotten more science. And so, I think the point that you made about, we're always going to have imperfect science is something that's really real to us, because every time we do a risk assessment, every time we try to understand whether or not an environmental exposure could be impacting health, it's based on the information that we have today. And if we have new information tomorrow, or there's a new toxicity study produced, or we develop a better way to quantitate the impact between benzene exposure and particle exposure and noise and stress, right? I mean, all of that would inform decision making in the future. So, I think where we want to go now is, to me, the critical questions related to setback have to do with how often people might see that acute exposure. And I think then the commission would be tasked with how often is acceptable, right? We've talked about before cancer risk, right? So I mentioned this briefly earlier, but cancer risk, cancer theory tells us that one molecule of a substance could cause cancer. So that's not 1 gram or 1 nanogram, you know, it's one individual molecule of the chemical, something that we could never measure, could never see, right? And so when we think about cancer risk, we can't say, here's the line in the sand below which you're reasonably safe. We have to say, what's that acceptable risk range? And for cancer, EPA has set that number to be somewhere, their target is somewhere between one excess cancer case in 1 million and 1 excess cancer case in 10,000. And just to put that in context, throughout America, the average person has a 1 in 3 chance of getting cancer, right? So you have a 30% chance of getting cancer, and now the acceptable risk range that they regulate at the federal level would make that a maximum of 30.01% chance of getting cancer, right? And while for these acute health risks, we're not talking about cancer, we're still talking about the distance and the number of people at each distance, right? I mean, I think that's really what your decision is based on. And so trying to understand, is there a distance at which we would think no people would ever be exposed to levels that could cause acute health impacts? And the answer there is, quite frankly, we can never say no, right? Scientific models and the way that we construct science doesn't really allow us to say 0% with any certainty, right? We could say 0.0000001%, but not 0. We could say nearly 0. And so, you know, I think really where we need to go is getting a better handle on those emission rates, how they may have changed since new technology has been employed, and then also what those exposure frequencies might look like at different distances. Commissioner Putnam, did you have more to add?
Thank you, Dr. Thank you, Dr. Richardson. So Commissioner McGowan, going back to your original question, I think, you know, we are, I think, in a position where we have more tools coming both from our engagement with COGCC as well as the last legislative session to really collect more and better data than Colorado's been able to collect in the past. We see that in part through the Firestone tragedy settlement that will result in additional capacity with a mobile monitoring van that we are in the process of ordering right now, with aerial studies, more work with CSU, University of Chicago, others, to collect more and better information. And then the legislature also authorized additional funding and new Colorado Air Quality Enterprise that will allow us to collect more information about what's out in the ambient environment, more information about leak rates or emissions rates, and then some of the health and other sort of impacts associated with that. And so to the point of how do we use that, because the science is uncertain and because we're learning, we want to use that learning as quickly as possible to inform good decision making. And that takes at least 2 tracks. The first is, first and foremost, we want to minimize emissions. That's a task that the legislature has given at the AQCC, but also COGCC. And so use that information as we're doing the upcoming rulemaking to inform new restrictions to minimize those emissions where we can find them and implement new controls. And then secondly, inform the information about the health effects that then may feed into questions related to setbacks or alternate locations or other sort of information that's going to be part of your process and the conversations that you have moving forward. And so, you know, I think one piece of good news in addition to that coordination, you know, on settlements and getting resources from the legislature is, I think, a strong and strengthening relationship between the research community and here in Colorado, which is exceptionally strong and really world leading on these issues, COGCC staff and then CDPHE staff, along with local public health, because they're out there collecting information. City and County of Broomfield collected a lot of data, for example, on some recent completions and other drilling operations in the Broomfield area. We're sharing that information. We're collaborating on a lot of these things. and trying to catch up on this information. Colorado is ahead, I think, of where the rest of the country is, because the federal government hasn't really been investing as much in this research. And so we're kind of trying to fill that gap and fill it as quickly as we can. So that's kind of where we are. I will say, you know, one specific area that is, you know, a challenge right now is we collected a fair amount of information along with Broomfield during recent flowback activities at the Livingston pad in Broomfield. We were hoping to do additional work to follow up on the health study, provide additional information, but with the current market conditions and COVID conditions, there's very little of that activity happening, and therefore very little ability to kind of collect that data out in the field. And so, you know, we are increasing our capability and we'll be prepared to do so. But right now, if that activity isn't happening, we can't collect that information.
Thank you, Commissioner Putnam. Commissioner McGowan, no more follow-up? Is that a wave? Other commissioners with questions? All right, seeing none, Ms. Richardson, or Dr. Richardson, we really appreciate your presentation this afternoon. It is highly informative for us as we dig through these issues. I'm gonna take chair's privilege and call for a 10-minute break so that I can move from this and get back into 400. It's 3:40, let's return at 3:50 for the last hour of deliberation on 400 series. As well as the 149 parties that we have with us. Welcome back. It is September 3rd at 3:50. We've got about an hour and 10 minutes left. We have a hard stop at 5 today. We have a few more areas of deliberation on the 400 series. I believe we had just finished up 411. And I am biding time so that Ms. Murphy can show up and help direct us to the next places we need to go. I think we were going backwards, which is, so 406B, 405, 404. But I would look to you, Director Murphy, for some guidance.
Thank you, Chair. A couple of things. Just give me 1 second. Okay, I think that should help manage reverberations. We've done a great job in the last couple of days of managing them. So we have 3 remaining slides, 404, 405, 406B. And I would like to start by framing, I think a number of the questions that commissioners have raised about these particular rule provisions relate to what notices staff is receiving pursuant to the 400 series. And I'd like to start by framing something that I think I neglected to frame when we first presented the 400 series, is that these notices are what staff needs to administer the act. And so the timeframes in them, what they include and how they function are really to help us do our jobs. And that's not something I said yesterday, and that was a huge omission, because I think that may help articulate why staff has had some concerns about adding information, changing days. We really look to the 300 series to build out the conversation and notice to folks who aren't staff. And so like, kind of, I think it was yesterday, maybe it was the day before, maybe it was last week, I said that there's like process, and then there's process. And here, again, we're in a space where we have like notices, and then notices. And when I think about many of the 300 series notices, they're really geared to initiate the conversation between the operator and the surface owner, the operator and the local government, COGCC, and the operator. And those are incredibly important conversations that set the foundation for how that relationship can continue through the life of the operation. In contrast, and when we pull back into the 400 series, when we're talking about sundries, when we're talking about Form 42s, which historically, and that history is not that long ago, and staff will be embarrassed that I'm admitting this, it was the notice of notification, right? Those are how we do business. When something is occurring on site, we need to know a day or two in advance, not 2 weeks in advance, so that our staff can integrate that information into our kind of risk-based inspection approach to inspections and get the right people to the right site on the right day. And so I appreciate the world's interest in these notices, but I don't want the commissioners to lose sight of the important role that they play in what it is that we do every day. And again, I didn't articulate that yesterday. I think sometimes I get so caught in the business of what it is that we do, I forget to frame why we're doing it. And so I will do better about that as we go forward, but wanted to start the conversation on 404, 405, and 406 with that kind of opening salvo. So, and then we can get into the substance of what else can we be doing and how can we make these work better or differently. So with that, I might chair, like reverse on my earlier position and just start with 404 because that's where my slide deck is queued up right now, if that's okay, unless anybody's dying to start with 406.
Did you just politely tell us that generally speaking, it's staff's position that the 400 series notices are really geared towards COGCC to ensure that it is reacting, that it is inspecting, that it is gathering what has either about to happen or what just happened, that sort of thing, and that it's more the 300 series notices that go out to collect people and parties together to discuss things?
Yep.
What is the first question? Whether to limit sundries to no net adverse impact?
Yep. And I'm happy to jump in on this if that's okay.
Or we can have the commissioner that identified it jump in on it as well. Either way. Commissioner Messner, we found the culprit.
Well, this is the topic that I brought up earlier, that if we're going to make adjustments to a 300 series submission that has notice, and that we're going to utilize the Form 4 in order to make adjustments to that 2A submission, and it is not a significant change, then we should determine that Form 4 is as protective or more protective than the 2A submission. And so that's where I went with the term no net adverse impact. I'm not hung up on that term, but that's where I continue to bring up this idea that if there's going to be a modification to a 2A submittal, that it needs to be as protective, if not more protective. And so that was the topic that I brought up, and it seemed like the appropriate place to bring it up.
May I, Chair?
Yes, Director Murphy.
Thank you. So I tend to think about sundries as kind of a couple of pieces. One is a sundry comes into us to say, hey, we as the operator need to start a formal conversation with you, the commission, about particular issues. Whether, as we move forward, as these rules are adopted, if 301 is adopted as staff has proposed, and I don't think we contemplated many changes to the provision around significant changes, that will necessarily limit staff's ability to consider changes to a facility or a location that would not be in compliance with 301C. And so is this a place where we consider building back in a cross-reference so that we connect those two dots more clearly? Is one thing to consider. While I have the floor, I may jump into the second question about sundries to just scope it. And again, sundries are really an important tool in terms of our communication with operators. They're also a significant amount of work in that in 2020 to date, we've received approximately 7,600 Form 4 sundries. And so as we think about what we provide to local governments, I don't know if local governments were aware of the volume of information that would come towards them through a sundry. And again, all of that information would be in the well file either way. Like there is a transparency component here that's important. So those are a couple of pieces of feedback on 404 in particular, Commissioner Mesner and other commissioners.
Does anyone want to jump in on this topic?
Sure, Mr. Chair.
Commissioner Messner.
Thank you. So I do think the cross-reference makes sense so that it is clear, and I do acknowledge that there is a significant number of Form 4s, and that local governments do have the ability, or anyone for that matter, to go into the website in order to be able to find this information. I do also acknowledge that local governments have permitting authorities and can put a condition on an operator that they are informed when certain activities happen. And so I think this is another important piece. I do think if the intent is to utilize the 300 series in order to start the conversation, then that conversation should include these communication items if there's concern between parties or governments that the communication is not happening. And so so I think that's okay if there's different ways of doing it rather than utilizing 400 series communication to provide notice to certain things. But at least what I'm hearing from parties is that there's some concern that maybe the amount of back and forth communication or notice may not be at the level that they're comfortable with.
Director Murphy.
I don't know that I heard a really specific question except an appreciation of the challenge and
Yeah, actually, I called on you because you were unmuted. I thought maybe you
Oh.
had something to say. That's fine. It's getting late in the day. Look, she quickly mutes herself. Other commissioners that would like to weigh in on this topic? Commissioner Nanjapa, then Commissioner Gonzalez.
Mr. Chair, thank you. I guess not specifically, and I appreciate that clarification from Director Murphy as it relates to kind of these notices in general. And so I guess my thought is more towards some of the other pieces, but you know, it maybe does apply to this one to a certain extent. Just the idea of whether there is still an opportunity to include some other consultation. I guess I'm still just more generally thinking about the idea that, you know, as you get closer to operations, you know, in part this sundries forum is to cover things that have changed. And, you know, some of the other notices also relate to, you know, things that are about to commence and how that sort of more immediate point in time is different, you know, from the broader overall sort of application as it relates to the location and the general operations that are going to be happening, if that makes sense. So, you know, I would look to you, Director Murphy, and the staff in terms of if that could be clarified. And again, just noting that if those notices are covered, or if that's part of your sort of discretion as director to engage other stakeholders, you know, that's all good. I just want to make sure that we're sort of covered in those, given that sort of difference in specific timing and, you know, certain matters that can arise that relate to receptors affected, if that makes sense.
Sure, Mayor.
Director Murphy.
Thank you. I'm actually prepared this time and didn't just inadvertently leave myself unmuted. Commissioner Nanjapa, I appreciate that. And we haven't gotten to the following two slides yet, and now I'm jumping around a bit. But I think that the commission's directive from earlier today around looking at whether and how to include sources of information around duration, and also how and whether to engage CPW. I mean, we talked about it a great deal around 436. I think that those directives from the commissioner filter through all three of these sets of rules too. And so I think we need to talk to CPW about whether getting notice of some of these, getting some of these notices is appropriate. And we will reach out to CPW and have that conversation. And if they say yes, we will flag it and make a suggested rule change and bring that back to you. We also will look at the forms and think about how the 300 series interrelates around the duration question to capture information at an appropriate scale, and also look back at the 300 series. Are there other places where we can flag that this is an important component of the conversation that we want you to be having with the folks in proximity, or receptors in proximity? I guess it's hard to talk to the elk, but maybe that's not the right place for the word receptors. So what I will say is, as we move on to the next slides, where I see conversations about wildlife or duration, I take the direction from the earlier conversation on the 400 series as applying equally to those pieces.
Thank you, Director Murphy. I appreciate that. And I didn't mean to sort of get you jumping around, but yeah, I just wanted to sort of make sure that that point was out there, but it seems like you're intending to cover that. So thank you. Appreciate that.
Other thoughts from commissioners? Commissioner Gonzalez.
Sure. Just some general thoughts on these two things, and I thought a lot about this during the testimony and during some of the questions we've had so far, in regards specifically to sundries. And when I think about limiting them to no net adverse impacts, I think that's kind of already built in. Well, first of all, I don't think that no net adverse impact for the Form 4 is necessarily necessary, because when the commission staff is reviewing any Form 4, they're doing it in a manner, looking at it in a way that they're regulating, that's in a way that's protective. And if there's anything that's beyond just ministerial or procedural, it comes to us for our review as well, in which case we can look at it and make sure that it is in a manner that is protective. But just because it has no net adverse impact versus, or in comparison to the 2A, or even if it is more impactful than the 2A, does not necessarily mean that it's not protective of public health, welfare, safety, the environment, wildlife, resources. So I'm comfortable with just letting the mission of the staff and the mission of the organization, of the commission, be the guiding light for how to review those Form 4s. So on that first bullet, that's my thought there. On the second one, with regard to sending sundries to local governments, I think if local governments want a sundry or want to understand a change to the local siting or to the siting applications, or they have the right within their land use authority to request that and to put that in their own regulations. And so anything above that, I think they could get from whatever comes out of the public records, but I don't think that we need an affirmative mandate or requirement that we send those sundries to local governments. So on those 2 points, that's where I stand.
I think I tend to agree with you, Commissioner Gonzalez. In particular, on the second point, that's not something that I think is rule thing. I think that's more local government designee working with our program, and we can do stuff like that through guidance if there's even a need for sundries to go to local governments. Other commissioners desire to weigh in here? Commissioner Messner, do we want to circle back to you on the no net adverse impact?
So keep in mind, this is something that I'm bringing up from stakeholders, so I'm not like, this isn't my thing, but at the same time,
Duly noted.
I do, I do think that, I do think it's worthy to put in the rule, and I don't think no net adverse impact is the right term, but I do think as protective, if not more protective than what was proposed in the 2A application is appropriate for as a requirement for a Form 4, only because while it may be inherent, that sometimes is not particularly clear when we're looking at an adjustment to a plan that was a submittal in a 300 series document. And so I think it's an appropriate thing to put in there, but I will also acknowledge that that is inherent as far as a review from staff, but these are rules that will live for a long time. So.
All right, well, I'm not seeing any other commissioners desiring to weigh in. I think as to the second point, then there seems to be consensus that that doesn't need to be in the rule. And maybe to the first point, we'll let staff have direction to think about it and then maybe come back to us because this is a part of that syncing up of 300 and 400 and changes, et cetera. And maybe you can, as you are coming back to us with rules on both sets of series, you can let this influence your thought process. And that's clear as mud direction. Everybody good? Moving on to 405. Director Murphy.
Thank you. So I think that we've talked about the duration piece, and if commissioners are comfortable with that direction, I know at least one is, so I'll take that one. I think that we've addressed the first point. I think that the conversation around wildlife would help us address the second point as well in terms of engaging with our partners at CPW. My point on the third one, I understand that La Plata would like 5 days, but again, from us administering our rules, 2 days is the right number. As you get further away from the actual activity, there are a couple of problems, right? Like it provides more flexibility for the operator. We have less precise information, and also we're trying to, our inspectors, and Mike should actually talk about this, not me, kind of get up every morning and take a look at the information provided by our risk-based inspection program to figure out what their highest priorities are to inspect that day and where to spend that time. And so if we start building in more days from the time a notice comes into us to the time that activity can occur, when we're talking about multiple sites, multiple wells, the matrix of that information starts to look more like a galaxy in terms of what could be happening where. And so the precision in this is actually important to us. And it's important enough that I think it's actually, let me look up the rule brief for just a moment. Right, so in Rule 405, we have added language that no Form 42 may be submitted more than 2 weeks prior to the scheduled activity, because at some point we've received notices 30 days in advance, and that doesn't help us carry out our inspection objectives. So I do have strong feelings about number 3. And then on number 4, regarding providing concurrent notification to local governments, the Form 42 and Rule 405 specifies exactly when, that local governments are getting fairly concurrent information forms sent to them for surface activities. And so we focused on getting them the information that we thought was most pertinent to what it is that they're doing every day, and not the information about the subsurface. I think that is something we can change, and if we wanted to give local governments Form 42s for everything, we could revise the rules to accomplish that. But that was our thinking in terms of how we structured what of the Form 42s go to local governments and which ones don't.
Okay, thank you for framing the issue. Do commissioners have thoughts? Commissioner Nanjapa.
Thank you. I will not mention anything related to the other points that I've already raised, but I did want to just note that with respect to La Plata's comments yesterday, one of the things that they mentioned is the fact that some of these fields are quite a ways out, and part of their concern was, I believe, as I understand it, was more sort of emergency preparedness and being able to sort of, notify some of the entities that might need to be aware and be able to, have folks ready in case there's an instance that requires their attention. So, I won't go beyond that in terms of just having you all be able to, keep that in mind as you're figuring out how to address that, or what would be the appropriate notice in that type of instance. I guess, if there's any additional thoughts that you or staff have with respect to that or how that's worked in the past, but that was just the one comment that was raised. And so I just wanted to make sure that that was at the fore as you're thinking through this.
Yeah.
Director Murphy.
Okay. Thank you, Commissioner Njaba. I think that's a great question, and there are a couple of layers to it, and especially in La Plata County, and we see this with our inspectors, right? They have to plan their inspection protocol in a pretty complicated way because of the rural nature, remote, and topography in the Southwest in particular. It's very much different from the inspections in the Northeast. And so again, this is our system and it works really well for us, and we recognize it doesn't work well for everybody. And so I think that on the one hand, La Plata can look at how to engage their operators to get the information that they need on a different time scale, is one tool that I think is very available to them too. And in this, and I think that the thing to keep in mind is that for me, the Form 42 notices they're very important. They're important activities, but it's different from kind of that true emergency situation. And I think that keeping in mind that, and Mike or Mr. Leonard is the perfect person to talk about this engagement of when there is something that is exceedingly time sensitive. We have phones and I think we use them, and it might be appropriate, Mike, if you want to talk about that kind of more, the time sensitive piece and how we engage with local responders in those instances. And Commissioner Njapa, if I've gone completely beyond your question, dial us back, but it seemed important to me to tier those two different components.
Mr. Leonard, before you answer, can I just throw something else out there? So I just went through Form Rule 405, and 7 of the notices has the commitment of the commission to immediately provide notice to the relevant local government. So I guess I hadn't caught that before. So there are, and these are the ones that are kind of the ones you would think about: the notice of seismic, notice of construction, notice of spud, etc. Mike, can you talk us through how that works? Does that work? But I did want to just get it out there that many of these, should we give relevant local governments concurrent notice? It's already in the rule.
So I believe we have, and Ms. Stanza can speak to this, but I believe in the new local government designee form 29, we've built in an opt-in or opt-out for notices. So local governments have the opportunity to get those notices. I do kind of understand their timing requirements. And again, going back to other commissioner statements, local governments can have operators through their land use notify them, say 5 days ahead, and then get our 42 that's the actual that we know they're going to move in 2 days, right? Because Director Murphy was absolutely right. If we get too far out, we were getting 42s for notices up to 2 months, 3 months ahead of time. And there's so much that happens in between then. So we put it on our calendar, and or we don't put it on our calendar, we forget about it. But then something happens in between and they say, oh, I can't be there. I told you 3 months ago, but now I can't be there. So that's why we want to get that time frame narrowed down to where, yes, we know you're going to be there, you're going to do this operation, and we need to be there at the same time. One other, and the opt-in, opt-out comes from the fact that not every, I'll admit to you, La Plata County does a great job because they share information across the board. There are other counties out there, this notice, because of who they've designated to be the local government designee to really receive this notice, may or may not transfer that on to emergency services. Okay, because we leave that in the county to do what they may. So I understand what La Plata is saying, and it's a great thing. And they're one of the great counties that they talk amongst themselves. But not every place wants that. Some counties don't even want notice. They don't want to be, burdened or whatever. And there's other counties that they get the notice, and we've gotten calls from the designee, and they say, what am I supposed to do with this? So it's kind of a juggling act for us, if that helps.
Mr. Chair, if I may add to that.
Yes, AAG Minor.
I think that this is a great preview of coming attractions. When we get to staff's presentation in the 600 series, you'll hear a lot more from Mr. Leonard about Rule 602J, which is really staff's attempt to ensure that that coordination happens between operators and emergency management agencies, and allows operators to work with their local emergency management agencies on a case-by-case basis to figure out what types of notification provisions and everything else that unique locality needs. So I will just leave it there, but want to make sure that everyone knows that's coming in the 600 series.
Always good to get a preview of what's coming. Do commissioners want to weigh in further on Rule 405? Commissioner McGowan.
So just thank you to staff for some of this background. I think it's helpful to understand why those timeframes are the way that they are, and hopefully this conversation is helpful to local governments who are listening as well. And I'm also appreciative that they're going to get prompt electronic notice at the same time that staff does, and so understanding the reasoning behind the timing for the notification and how staff uses it, I think I'm okay leaving it the way that it is.
Me too. Other commissioners?
Same here.
Gonzalez? Okay. Director Murphy, do you feel that you now have direction on the bullets on slide 3, Rule 405?
Chair, I do, and commissioners, thank you for understanding. Turning to 406B, I think we can acknowledge the kind of duration wildlife components of this as well. I will tell you that staff feels incredibly strongly that the rule that we crafted for preset conductors is appropriate. I think we spared you a lot of our experience with preset conductors and the challenges that they've posed, and the wildlife impacts that we've seen from them. If you would like to, I'm happy to unleash our team on this, but we feel very strongly about the preset conductor rule. We think it's protective. We think it's critically important. And I also think that the reason that preset conductors look as good as they do today is because of the work that staff has implemented, especially in the last few years through guidance and through policy, because of the suite of problems that we saw, especially across the in the Western Slope. So I won't dive too much further into that, but I'm happy to bring forward any of the information that you think would be appropriate to understand our concerns. And then on the notice to occupants, owners, tenants within 2,000 feet, 406B is really to help inform COGC staff that operations are forthcoming, so that we can respond to complaints or conduct inspections as are appropriate. 412B is really what we've used to help guide the engagement between the operator and the occupants, owners, tenants. So I think that the issue is covered, but we're happy to explore it further if it's appropriate.
This commissioner certainly feels comfortable relying on staff, on the preset conductors, and on the notice issues. Other commissioners with thoughts? Commissioner McGowan.
I'm good as well.
Got a thumbs up from Commissioner Nanjapa. I got a lean from Commissioner Gonzalez. Commissioner Messner, do you have thoughts? It looks like you're frozen. Maybe you're just really still.
No, I'm good.
Director Murphy?
Well, I feel great about it. I mean, staff feels very great about its 400 series rules, recognizing there are places to clean them up, and I think that you've given us direction to help work on a number of those places. Really, I mean, we can always add refinements, and I think the 411 conversation is particularly exciting in that arena. So with that, I would say that we have worked through direction to staff on 400 series, and thank you.
Thank you. Thanks to our stakeholders for the really good testimony, evidence, pre-hearing statements, responses, written testimony. It has helped influence the process. I think it's helped get us to a good conceptual spot. Thanks mostly to staff. I know that this has been this is a very technical place. This is where the decades of staff history and working on these sorts of things really comes to play. I said it once, I'll say it again, I'll say it till I'm done here. This staff is remarkable. So we really appreciate that. It is 4:26. I would propose that we stop for the day and give staff this additional 34 minutes to continue to get ready for 600 series. That's next on our agenda. Are commissioners comfortable with that? All right, seeing a bunch of nods. Director Murphy, are you good with that? You're not. Okay. With that, I would look for a motion to adjourn until September 4th at 9 a.m.
I move to adjourn until September 4th at 9 a.m.
Second.
All right, we have a motion and a second. All those in favor by saying aye.
Aye.
Any opposed? We are adjourned. Thank you, Colorado.